Hello, everyone. I'm delighted to be with you today to talk about the Hong Kong Stock Exchange's listing rule changes, which came into effect on the 4th of August 2025, as well as the further consultation on ongoing public float. During the course of today's webinar, I'm first going to discuss the tiered initial public float requirement, and then go on to discuss the changes to the method of calculating public float, as well as the new initial free float requirement, which came into effect on the 4th of August 2025. After that, I'll discuss the further consultation on the ongoing public float requirements, including the consequences of significant public float shortfall, as well as the other listing rule changes. On the 4th of August 2025, the Hong Kong Stock Exchange made major changes to the listing rules, including a reduction in the portion of IPO shares available for retail allocation and in the public float requirement for companies listing on the stock exchange. The changes came as the stock exchange regains its position as the world's top IPO fundraising platform and sees record southbound buying of Hong Kong Stock Exchange listed stocks through Stock Connect. Hong Kong's IPO market experienced a significant resurgence in the first half of 2025, raising 107 billion Hong Kong dollars in 42 listings. The remarkable performance was fueled by a rise in A and H listings, notably the listing of CATL, the world's biggest electric vehicle battery manufacturer, which together contributed over 70% of the IPO funds raised on the Hong Kong Stock Exchange during the period. While most of the proposed listing rule changes were adopted, some of the key proposals have been modified. The percentage of IPO offer shares required to be allocated to the placing tranche has been reduced to 40% from 50% in the original proposal, and the maximum clawback allocation to the retail tranche has been increased to 35% from 20% under the original proposals. Other proposals were not adopted, including the 6-month lockup on IPO cornerstone investors, which has been retained, and the stock exchange did not adopt the proposed upward adjustment of the final IPO price. Despite significant support for a new OTC board to trade delisted and suspended shares and those unable to meet the Hong Kong Stock Exchange listing rules eligibility criteria for listing, the stock exchange said only that it will continue consulting with stakeholders regarding the feasibility of an OTC market and will update the market on any progress. As indicated in the stock exchange's consultation paper on proposals to optimize IPO price discovery and open market requirements published in December 2024, having received support for its tiered initial public float requirements, the stock exchange has launched a further consultation on the ongoing public float requirement. The proposals are set out in Part 4 of the stock exchange's conclusions and further consultation paper entitled Proposals to Optimize IPO Price Discovery and Open Market Requirements, published on the 1st of August 2025. The deadline for responding to this further consultation is on the 1st of October 2025. The listing rule changes are now in effect and apply to all companies listed on the Hong Kong Stock Exchange's main board and GEM, and to new listing applicants publishing listing documents on or after the 4th of August 2025. The stock exchange has also updated its guide for newly listing applicants to reflect the listing rule changes. The revised main board listing rule 8081 has implemented tiered initial public float thresholds based on the listing applicant's expected market value at listing in 3 separate tiers, A, B, and C. For Tier A, listing applicants with an expected market value of the relevant class of securities at listing of 6 billion Hong Kong dollars or less will need a minimum public float percentage of 25%. Tier B will require listing applicants with 6 billion Hong Kong dollars to 30 billion Hong Kong dollars or more to have a minimum public float percentage of the higher of the percentage that would result in the expected market value of publicly held securities being 1.5 billion Hong Kong dollars at the time of listing and 15%. Tier C is for listing applicants with an expected market value of 30 billion Hong Kong dollars or more, in which the minimum public float percentage must be the higher of the percentage that would result in the expected market value of publicly held securities being 4.5 billion Hong Kong dollars at the time of listing and 10%. The consultation paper originally proposed a 4th tier, Tier D, for listing applicants with a market value of 70 billion Hong Kong dollars or more. However, the stock exchange did not adopt the proposed Tier D to respondents' comments that very few listing applicants are within this category. Instead, the stock exchange will determine the appropriate public float requirement for listing applicants listing shares with a market value at listing significantly above 45 billion Hong Kong dollars on a case-by-case basis. The same initial public float thresholds apply to GEM listing applicants under GEM Listing Rule 13.37b. The new tiered public float thresholds apply to all applicants listing shares except for PRC companies listing H shares that have other shares listed on overseas regulated exchanges, for example, A and H share issuers. These are subject to different initial public float requirements, which I'll discuss later. The initial public float requirement applies to any class of equity securities listing on the Hong Kong Stock Exchange, including convertible equity securities, options and warrants, as well as shares. The revised listing rule changes have also removed the requirements for shares with weighted voting rights, which must be unlisted, to be included in the denominator when calculating the public float of issuers with weighted voting rights structures. It has also introduced Mainboard Listing Rule 18B05A, which removes the requirements for promoter shares and promoter warrants to be included in the denominator when calculating a SPAC's public float. The public float requirement under Mainboard Listing Rule 8081 requires a percentage of a listed company's shares to be held by the public. As mentioned earlier, that percentage was previously 25% for Mainboard and GEM companies, although the stock exchange allowed a lower percentage for companies listing on the main board with a market cap of 10 billion Hong Kong dollars or more. In calculating the public float for certain types of companies, the listing rules allowed shares to count towards the public float, that is, to be included in the numerator that the stock exchange considered did not contribute to an open market in Hong Kong. For example, in the case of Chinese A and H share issuers, publicly held A shares listed on mainland Chinese domestic stock exchanges counted towards the public float, despite not being tradable in the Hong Kong market. Under the revised listing rules, the public float is normally calculated as a percentage of the total number of shares or other securities of the class being listed only. So in the case of a listing applicant with only one class of shares on listing, to meet the public float requirement, the number of shares held by the public must be the specified percentage of its issued shares. This has not been changed from the previous listing rules. The basis of calculating the public float percentage has changed for H share issuers. Essentially, only the publicly held H shares and not any publicly held A shares listed on mainland Chinese exchanges as previously will count towards the public float. These publicly held H shares need to meet the relevant percentage of the PRC issuer's total issued shares of the same class as its H shares, which include its domestic unlisted shares and shares listed on mainland Chinese exchanges such as A shares. For H share issuers with no other listed shares, there's no change to the calculation. Their public float is calculated by reference to their publicly held H shares as a percentage of their total issued shares. That is, the total of their issued H shares and unlisted domestic shares. The public float of PRC companies listing H shares on the Hong Kong Stock Exchange is now calculated as the number of their publicly held H shares as a percentage of all their issued shares, including their H shares and their listed domestic shares, i.e. A shares, and unlisted shares that are in the same class as its H shares. Under PRC law, a PRC company's listed and unlisted domestic shares are considered to be the same class of shares. The change from the previous listing rules is that issuers' publicly held A shares are no longer counted towards the public float, i.e. included in the numerator of the calculation, but remain included in the denominator along with unlisted shares. The calculation is the number of H shares in public hands divided by the issuer's total issued shares, including domestic unlisted and listed shares, that is, A shares. The stock exchange did not adopt the proposal to align the public float requirement for PRC issuers, other than A and H issuers and non-PRC issuers, with shares listed on other overseas regulated exchanges with the requirements for H share listing applicants having other listed shares, that is, A and H share issuers. This is due to a lack of listed companies in this category. Most dual-listed companies, including those with depository receipts or depository shares listed offshore, are not, quote, issuers with other share classes listed overseas, unquote, because the shares underlying their depository receipts or depository shares are in the same class as the shares listed on the Hong Kong Stock Exchange and are fungible with them. The public float of companies with depository receipts or shares listed on an offshore exchange is therefore calculated by including the shares listed on the Hong Kong Stock Exchange and shares represented by offshore listed depository receipts or shares in both the numerator and denominator. The stock exchange also clarified that in calculating their public float, listing applicants should only count shares that have already been issued. They should not count shares that may be issued in future on the exercise of options, for example, under an over-allotment option or share option schemes. Under the previous listing rules, namely Main Board Listing Rules 824 and Notes 2 and 3 to the GEM Listing Rules 11.23, the definition of the public excluded any core connected person of the issuer, any person whose acquisition of securities has been financed directly or indirectly by a core connected person, any person who's accustomed to take instructions from a core connected person in relation to the acquisition, disposal, voting, or other disposition of securities of the issuer, registered in their name or otherwise held by them, and the issuer as the holder of legal or beneficial interests in treasury shares. The stock exchange considered that the previous definition of the public would mean that shares held by a trustee on behalf of specified share scheme participants of a share scheme of a listed issuer would normally be regarded as being in the hands of the public, even though most of these shares, especially shares that are yet to be allocated to any grantees, would be held by the trustee under the instruction of the issuer. To address this issue, now the definition of the public has been revised to additionally exclude any person whose acquisition of shares has been financed directly or indirectly by the issuer or any of its subsidiaries or a core connected person of the issuer, as well as any person who is accustomed to take instructions from the issuer or any of its subsidiaries or a core connected person of the issuer. The stock exchange has clarified that the requirement under Main Board Listing Rule 809.1 and GEM Listing Rule 11.23.2 that the listing applicant's publicly held shares at listing must have a minimum market value of 125 million Hong Kong dollars or 45 million Hong Kong dollars in the case of GEM listing applicants refers only to the publicly held shares being listed in Hong Kong. The listing applicants' other publicly held shares, whether listed offshore or unlisted, are now not counted in satisfying whether the market value requirement is met. The requirements for listing applicants to disclose the expected percentage of public float upon listing in the listing document still applies. The Hong Kong Stock Exchange now also requires listed companies that list a new class of securities to disclose the expected percentage of public float of the relevant class of securities on listing. According to the Stock Exchange's revised guide for new listing applicants, a listing applicant or listed issuer must disclose in its listing document the prescribed minimum public float percentage applicable to the class of securities being listed in different scenarios. That is, if the offer price is fixed at the bottom end, midpoint, or top end of the offer price range. According to the Stock Exchange, this requirement aims to inform investors of how the final offer price will impact the securities market value and the minimum public float threshold that applies. The Stock Exchange now also requires the prescribed minimum public float percentage threshold determined based on the final offer price, as well as a statement confirming compliance with the applicable public float threshold immediately after completion of the offering to be disclosed in allotment results announcements. The Stock Exchange has reduced to 10% from 15% the portion of the total shares that companies with other listed companies must list on the Hong Kong Stock Exchange. In the case of a new applicant H-share issuer with other listed shares, for example, an A and H issuer, the H shares being listed on the Hong Kong Stock Exchange must at the time of listing represent at least 10% of its issued shares, excluding treasury shares, or have an expected market value of at least 3 billion Hong Kong dollars. In the case of a non-PRC new applicant with other share classes listed overseas, the class of shares being listed on the Hong Kong Stock Exchange must, at the time of listing, either represent at least 10% of the total number of issued shares, excluding treasury shares, or have an expected market value of at least 3 billion Hong Kong dollars. The public float threshold requirement for new listing applicants that are A and H share issuers is the same as the minimum portion of shares they must list on the Hong Kong Stock Exchange. These listing applicants must therefore have publicly held H shares that either represent 10% of their total issued shares or have an expected market value at listing of 3 billion Hong Kong dollars. However, the stock exchange has decided not to apply that same public float threshold to other prescribed types of issuers, that is, H share issuers with other listed shares, but not an A and H share issuer. This being an H share issuer with shares of the same class as its H shares listed on overseas regulated markets, and issuers with other share classes listed overseas. This is because for most dual-listed companies, including companies with depository receipts or shares listed on an offshore exchange, for example, US-listed ADSs, the shares underlying the depository receipts or shares are of the same class as the shares listed on the Hong Kong Stock Exchange. The revised listing rules include a requirement that on listing, a portion of a new listing applicant's publicly held shares must be free of restrictions on their disposal. I'll reference this going forward as the initial free float requirement. The revised listing rules now require that at the time of listing, the shares that are held by the public and have no restrictions on their disposal must either represent 10% or more of the shares being listed and have an expected market value at listing of at least 50 million Hong Kong dollars for main board listing applicants or 15 million Hong Kong dollars for GEM listing applicants, or have an expected market value at listing of at least 600 million Hong Kong dollars. H-share listing applicants with no other listed shares are required to have publicly held H shares that have no restrictions on disposal, that either represent 10% or more of the total number of issued shares in the class to which the H shares belong, and have an expected market value at listing of at least 50 million Hong Kong dollars. For GEM, this is 15 million Hong Kong dollars, or have an expected market value at listing of at least 600 million Hong Kong dollars at the time of listing. This proposal was adopted despite respondents commenting that since the existing shares issued before the listing of an H-share issuer are subject to a 12-month lockup period under PRC law, the new requirement means that H-share issuers have to rely on newly issued H shares in order to satisfy the requirement. The free float requirement for H-share issuers with other listed shares, such as A and H share issuers, requires that the publicly held H shares that are free from restrictions on disposal at listing must represent at least 5% of the total number of issued shares in the class to which the H shares belong, that is, the A and H shares in the case of A and H share issuers, and have an expected market value at listing of at least 50 million Hong Kong dollars. Alternatively, the publicly held H shares that are free from restrictions on disposal at listing must have an expected market value at listing of at least 600 million Hong Kong dollars. This represents a change from the original proposal, which was that the free float percentage for A and H share issuers should be determined based only on the total number of H shares. Some respondents to the consultation commented that this could result in the free float for H share issuers with other shares listed on another regulated exchange being too small to be meaningful. According to the consultation conclusions, all A and H share issuers listed on the Hong Kong Exchange between 2020 and 2024 would have met the revised requirement. The new free float requirement on listing only applies to listings of shares. Under the new rules, shares held by an independent trustee under a share scheme are not counted towards the initial free float requirement, since they're typically subject to vesting conditions and are not available for immediate trading. The new free float requirements have replaced the previous free float requirements that applied to biotech and specialist technology companies. New listing applicants are required to include in their listing documents and allotment results announcements a statement of compliance with the free float requirement. Given the changes to the initial public float requirements, the stock exchange is proposing consequential amendments to the ongoing public float thresholds that require the publicly held shares listed on the Hong Kong Stock Exchange to represent at all times at least 25% of the total number of issued shares in the class of shares listed on the Hong Kong Stock Exchange, excluding treasury shares, or any lower public float percentage prescribed by the Hong Kong Stock Exchange at listing, which I'll refer to as the initial prescribed threshold. An alternative ongoing public float threshold, which I'll refer to as the alternative threshold, is proposed, which would require the publicly held shares listed on the Hong Kong Stock Exchange at all times to have a market value of at least 1 billion Hong Kong dollars and represent at least 10% of the issuer's total number of issued shares in the class of shares listed on the Hong Kong Stock Exchange, excluding treasury shares. This alternative threshold is intended principally for listed companies with a market cap of 4 billion Hong Kong dollars or more, since 25% of their listed shares will have a market value that meets the 1 billion Hong Kong dollar requirement. Most Hong Kong Stock Exchange listed companies will have to comply with the initial prescribed threshold and maintain the percentage public float that applies to them on listing. A listed company would not be allowed to rely on the alternative threshold if its shares have traded for less than 125 trading days after listing on the Hong Kong Stock Exchange. However, the stock exchange may require the listed company to extend the 125 trading days for determining the share's market value if during the period its listed shares have been suspended from trading for more than 5 consecutive days. According to the stock exchange, this alternative threshold is suggested in response to respondents' feedback to allow issuers whose public float has a significant market value greater flexibility to carry out transactions for capital management purposes, such as share buybacks after listing. Issuers opting for the alternative threshold would be required to publish an announcement giving reasons for relying on the alternative threshold and information on the actual market value and percentage of their public float. Both the initial prescribed threshold and alternative threshold also applies to H-share issuers with no other listed shares. The ongoing public float threshold would apply only to shares listed on the Hong Kong Stock Exchange. The Hong Kong Stock Exchange is proposing that H-share issuers with other listed shares, such as A and H issuers, should be subject to bespoke ongoing public float thresholds. This would require the publicly held H shares at all times to have a market value of at least 1 billion Hong Kong dollars, or to represent at least 5% of the total number of shares to which the H shares belong, including their H shares and A shares, but excluding any treasury shares. Under the listing rules, the Hong Kong Stock Exchange can suspend the listing of shares of a listed company that has failed to maintain sufficient public float. In the consultation paper, the Stock Exchange sought views on whether it should retain its practice of suspending trading of listed companies whose public float falls below 15%, or 10% in the case of companies granted a lower public float percentage on listing. Following feedback, the Stock Exchange is now consulting on the proposed alternative consequences to suspension of a mechanism to help investors identify listed companies with a substantial public shortfall and increased disclosure obligations. While the ongoing public float obligations are being consulted on, the Stock Exchange has made certain transitional amendments to the listing rules ongoing public float requirements. New applicants listed with listing documents published on or after the 4th of August 2025 under the new initial public float requirements must maintain the relevant minimum public float percentage prescribed at the time of their listing at all times until the new ongoing public float requirements are implemented. This means 25% or any lower minimum percentage prescribed at the time of listing, except for H-share issuers with other listed shares which are subject to bespoke requirements, or in the case of an H-share issuer with other listed shares, for example, an A and H issuer. H shares held by the public that represent either 10% of the issuer's total number of issued shares in the class to which the H shares belong, excluding treasury shares, or for issuers listed in reliance on the market cap of 3 billion Hong Kong dollars, the percentage derived by dividing 3 billion Hong Kong dollars by the total market value of the issuer's total issued shares in the same class as the 8 shares at the time of listing. Other listed companies will remain subject to the existing ongoing public float threshold that applied on listing, that is 25%, unless the stock exchange accepted a lower public float percentage on listing. If a listed company's public float drops below the required minimum, the stock exchange retains the right to suspend trading in its shares until steps have been taken to restore the public float. In determining whether the market value of publicly held shares meets the market value limit of the alternative threshold, the market value of shares is now determined on a rolling basis by multiplying the number of shares held by the public on the day of determination by the volume-weighted average of the shares listed on the Hong Kong Exchange over the preceding 125 trading days. A listed company whose shares have traded for less than 125 trading days would not be able to rely on the alternative threshold. The stock exchange does not propose to allow listed companies to let their public float fall below the initial prescribed threshold or the alternative threshold. The stock exchange will not grant waivers in this situation, and the failure to maintain the public float at the required level will constitute a listing rule breach. In the consultation paper, it said that one of the problems with suspending a listed company's shares is that it deprives the shareholders of an exit route, given that Hong Kong lacks a market for trading suspended and delisted shares. 81% of consultation respondents supported the establishment of an OTC market in Hong Kong as a market for delisted issuers and other securities unable to meet the stock exchange's listing criteria. In the consultation conclusions, the exchange said it would continue to work with various stakeholders on the viability of an OTC market and would update the market on its progress in due course. The ongoing public float disclosure requirements proposed in the consultation paper will only be implemented when the stock exchange concludes its consultation on the ongoing public float requirements I talked about earlier. At that time, the listing rules would be revised to require listed companies to disclose their actual public in their annual reports and information on their shareholding composition. The information that listed companies would have to disclose regarding the composition of ownership of the relevant class of Hong Kong Stock Exchange listed shares at the end of their financial year will include shares held by certain categories of shareholders who are not members of the public. These include substantial shareholders of the listed issuer and their close associates, identified on an individually named basis, directors, supervisors, and the chief executive of the listed issuer and their close associates, identified on an individually named basis, and other persons excluded from the definition of public, including directors, chief executives, and chief executives of the listed issuer's subsidiaries and their close associates, and other people outside the definition of the public, such as people accustomed to taking instructions from a core connected person. Disclosures relating to shares held by certain categories of public shareholders will also be required. These are any persons that are defined as the public and have disclosed their interests pursuant to Part 15 of the SFO, identified on an individually named basis, an independent trustee holding granted but unvested shares of a share scheme on behalf of the independent share scheme participants and other members of the public. Disclosure will have to be made based on information that's publicly available or within the knowledge of directors in preparing the annual report. Reasonable efforts will be required to determine the actual public float for the purpose of making the disclosure. The stock exchange suggests listed companies could, for example, require their core connected persons and other shareholders they have identified as non-public shareholders to notify them of their shareholdings and subsequent changes to them. In response to concerns raised by respondents, the stock exchange noted that although disclosure based on publicly available information may not reflect the most up-to-date public float information of a listed company as at the date of the publication of its annual report, it considers that the information may still be useful to existing shareholders and potential investors. Any caveats and assumptions relating to the disclosure should be included to facilitate understanding of the disclosure. In addition to the ongoing public float disclosure in listed companies' annual reports, the stock exchange is now consulting on certain additional public float disclosures. First, the exchange is proposing to require all listed companies to confirm whether they have met the applicable ongoing public float threshold in their monthly returns and annual reports. Monthly reporting would require disclosure in each monthly return as of the end of the month. For listed companies relying on the initial prescribed threshold, the minimum percentage threshold applicable to the listed company. For listed companies relying on the alternative threshold or H-share issuers with other listed shares, such as A and H shares, relying on the market value limit of the bespoke ongoing public float threshold, the market value and percentage of the portion of the class of Hong Kong Stock Exchange listed shares that are publicly held. Annual reporting would require disclosure in each annual report of the same information proposed in their monthly returns as at the end of the relevant financial year. The exchange is also proposing to require all listed companies to state in their annual reports the structure of their share capital as at the end of the relevant financial year. This disclosure would have to include details of the different types and classes of securities, together with the percentage for each type of shares as a percentage of the total number of shares, the ranking of each type of shares, and details of any special voting rights structure, if applicable. The disclosure would have to be made based on information that's publicly available to the listed companies or otherwise within the knowledge of their directors. The exchange considers that this additional disclosure would better inform investors of listed companies' public float status and any shortfall that may lead to the risk of delisting. The table on this slide summarizes the proposed regular public float reporting obligations relating to different types of listed company. All listed companies would need to provide a confirmation of compliance with ongoing public float percentage in monthly returns and annual reports. Listed companies relying on the initial prescribed threshold will need to report their minimum public float percentage threshold in monthly returns and annual reports. All listed companies will need to report their actual public float percentages in their annual reports, but only listed companies relying on the market value-based thresholds will need to report in their monthly returns. Listed companies relying on the market value-based thresholds will also need to report on their actual public float market value in their monthly returns and annual reports. All listed companies will need to report on their share ownership composition and share capital structure in their annual reports. Falling below the required ongoing public float threshold will be a breach of the listing rules. A listed company would have to take active measures to restore its ongoing public float threshold as soon as possible. The listed company would be required to make an announcement of the listing rule breach. This would include publishing an announcement within 1 business day of becoming aware of a public float shortfall, setting out the market value, if applicable, and percentage of its public float, and the reason for the listing rule breach, and announcing its plan and expected timeline to restore the applicable ongoing public float threshold as soon as practicable. If this information is not available at the time of the initial announcement, it can be announced in a subsequent announcement published within 15 business days of it becoming aware of the public float shortfall. The exchange is proposing that a listed company with a public float shortfall must also provide monthly updates by way of announcement to inform the market of the status of its public float, including the market value, if applicable, and percentage of its public float, and updates on its restoration plan. The exchange is also proposing to clarify that for so long as a company does not comply with the applicable ongoing public float threshold, the listed company and each of its directors must not take any action that may further lower the company's public float percentage unless the circumstances are exceptional. Examples of these actions including a share repurchase by the listed company or an acquisition of shares by its directors or their close associates. The exchange is proposing not to suspend trading purely due to a shortfall below certain public float thresholds. Previously, suspension was required when the public float fell below 15% or 10% for lower threshold issuers. Instead of being suspended, listed companies with a significant public float shortfall will be marked with a special stock identifier in their stock short name. These listed companies would also face additional disclosure obligations and may face delisting if the public float is not restored within a designated period. A public float shortfall will constitute a significant public float shortfall unless the listed company's publicly held Hong Kong Stock Exchange listed shares represent at least 15% of the total issued shares in the class, or at least 50% of the initial prescribed threshold for issuers with a minimum public float percentage below 25% at initial listing, or have a market value of at least 500 million Hong Kong dollars and constitute at least 5% of the listed company's total issued shares in the class of listed shares, excluding treasury shares. The second limb will not apply if the listed company's shares have traded for less than 125 trading days since listing. For H-share issuers with other listed shares, a public float shortfall will be deemed a significant public float shortfall unless their publicly held H shares, 1, have a market value of at least 500 million Hong Kong dollars, or 2, constitute at least 5% of the total shares in the same class as the H shares, excluding treasury shares. The threshold for a significant public float shortfall applicable to H-share issuers with other listed shares would also apply to non-PRC issuers that have part of their share class listed on a PRC stock exchange. For example, RMB denominated shares listed on a PRC exchange by a non-PRC company. This applies when those shares are in the same class as, but are not fungible with, the shares listed on the Hong Kong Stock Exchange. In this context, references to H shares are adjusted to mean the shares listed on the Hong Kong Exchange. In determining the market value components of the ongoing public float threshold, the market value thresholds for determining whether there is a significant public float shortfall would be determined by multiplying the number of publicly held shares at the determination date by the volume-weighted average price of the shares listed on the Hong Kong Stock Exchange over 125 consecutive trading days, or for H-share issuers with other listed shares, for example, A&H share issuers, all trading days since listing, if shorter, immediately before the determination date. The Hong Kong Exchange is proposing that if a special stock marker has been applied, the listed company should be delisted if it fails to restore its public float to meet the applicable ongoing public float threshold within 18 months or 12 months for GEM from the start date of the significant public float shortfall. Listed companies with a special stock marker would be subject to the additional disclosure requirements. Within 1 business day of becoming aware of a significant public float shortfall, the listed company must publish an announcement confirming this fact. The listed company must also include an appropriate warning statement in all announcements and documents required to be published by the listing rules. This warning should notify the market that the listed company's shares will be delisted if it does not restore its public float to the required ongoing public float threshold within the designated period. Additionally, it should advise shareholders and investors to exercise caution when trading its shares. The stock exchange will only remove the special stock marker when the listed company has restored its public float to meet the applicable ongoing public float threshold. The listed company will need to publish an announcement of the restoration of its public float. The stock exchange is proposing to clarify that as long as a listed company is in breach of the public float requirement, the listed company, its directors, and their close associates will be prohibited from taking any action that could further reduce the percentage of the company's public float. However, this will not apply in exceptional cases. For example, when a listed company with a public float shortfall later seeks to privatize through share repurchases via a general offer. Sanctions can be imposed on a listed company's substantial shareholder who causes or knowingly participates in a listed company's breach of the listing rules. The stock exchange has said that it may apply these provisions to sanction a substantial shareholder that causes or knowingly participates in a breach of the listed company's public float requirement, for example, by buying shares. Although the stock exchange would not halt trading in a listed company's shares solely because of a public float shortfall, it will retain the authority to order a trading halt or suspend dealings in any listed company securities if there are signs of a false market. Additionally, if the stock exchange suspects that a listed company's securities may be predominantly held by a small group of shareholders to the detriment or without the knowledge of the investing public, it will have the right to require the listed company to publish an announcement informing investors that shareholding may be concentrated among a few shareholders and advising caution when trading in its securities. The stock exchange also has the right to conduct an investigation under Section 329 of the SFO and publish the results of that investigation. The exchange proposes applying the ongoing public float requirement only to shares listed on the Hong Kong Stock Exchange and not to convertible securities, options, warrants, or similar rights to subscribe for or purchase shares or convertible securities. All existing listed companies would be subject to the proposed ongoing public float requirements. The stock exchange is proposing to retain the existing requirement for takeover code offerors to commit to restoring any public float shortfall upon completing an offer if they intend the company to remain listed, and include this commitment in the offer document. It's also proposing to make related amendments to the listing rules to require offer documents to clearly state that a special stock marker might be imposed if a significant public float shortfall occurs after the offer, and that the company could face delisting if it does not restore its public float within the specified remedial period. Also, the exchange proposes to keep the existing practice that the Hong Kong Exchange may grant a timing relief waiver to a listed company from the ongoing public float requirement for a reasonable period following a general offer in order to allow time for restoration of the public float. The waiver would be conditional on the listed company being subject to the same disclosure obligations as if it had violated the public float requirement. However, a timing relief waiver would not be granted if, after the completion of the offer, the public float shortfall qualifies as a significant public float shortfall. The stock exchange has retained the 6-month lockup on Cornerstone investors, dropping a proposal to release 50% of Cornerstone investors' locked up shares after 3 months. The revised listing rules require at least 40% of the IPO offer shares to be allocated to the book-building placing tranche of an IPO instead of 50% as originally proposed. The exchange has adopted its proposal not to apply the new 40% placing tranche allocation requirement to specialist technology companies listing under Chapter 18C of the Main Board listing rules. Instead, these companies remain subject to the requirement to allocate at least 50% of the total offer shares to independent price-setting investors. The revised listing rules have removed the guideline on the minimum spread of placees in the placing tranche, which previously required at least 3 holders for each 1 million Hong Kong dollars of the placing and a minimum of 100 holders in the IPO placing tranche. However, the minimum shareholder spread requirement remains and requires a minimum of 300 shareholders on a main board listing and a minimum of 100 shareholders on a GEM listing. The exchange also has discretion to reject a listing applicant that fails to demonstrate there will be an adequate spread of placees. Given the removal of the guideline thresholds, it has included guidance on the requirement in the Guide for New Listing Applicants in Chapter 4.15 at paragraph 3. The revised listing rules have replaced the previous minimum allocation of shares to the public subscription tranche with a requirement that listing applicants adopt either Mechanism A or Mechanism B. The maximum clawback allocation has, however, been raised to 35% from 20% under the original proposal, due to concerns that the listing rules would not otherwise accommodate strong public demand for some IPOs. The highest clawback allocation has been set at 35%, as the midpoint between 50%, the highest clawback allocation under the previous listing rules, and 20%, as proposed in the consultation paper. The prescribed share allocation to the public tranche under Mechanism A under the revised listing rules is now 5% at initial allocation, 15% where demand for shares in the public tranche is more than 15 times to less than 50 times of the initial allocation, 25% where demand is more than 50 times to less than 100 times of the initial allocation, and 35% where the demand is more than 100 times the initial allocation. The alternative mechanism B requires a minimum initial allocation of 10% of the offer shares, up to a maximum of 60% to the public subscription tranche, but has no clawback mechanism. The previous clawback trigger points under mechanism A have been retained as the stock exchange did not want to increase them to respond to the inflated oversubscription multiples commonly seen on IPOs, as some respondents have suggested. The stock exchange may provide individual waivers from the mandatory allocation mechanism on a case-by-case basis, following the previous practice for listing applicants with large offer sizes, including both typical and non-typical waivers as outlined in the stock exchange's guidance in the Guide for New Listing Applicants, Chapter 4.14, paragraphs 4 to 7. These decisions will be made based on the specific facts and circumstances of each case. The stock exchange will maintain the existing criteria for typical waivers as specified in its guidance, and the conditions that trigger these waivers will align with the clawback trigger points under mechanism A. Specialist technology companies listing under Chapter 18C of the Main Board listing rules are required to use the allocation and clawback mechanism designed for them as set out in Main Board Listing Rule 19C09. The Hong Kong Stock Exchange has retained the cap on the reallocation of offer shares from the placing tranche to the public subscription tranche, or the reallocation, and on the overallocation of offer shares to the public subscription tranche, or the PO over allocation. The aim of these restrictions is to reduce the risk of investors in the public subscription tranche being quote-unquote stuffed with shares at a price that is unattractive to participants in the placing tranche. Given the changes to mechanism A from the original proposals, the exchange has made consequential changes to the triggering conditions of the restrictions on reallocation and PO overallocation as set out in the tables on the slides. In particular, having considered the substantive comments made by respondents, the exchange has adopted the proposed maximum allocation cap percentage threshold of 15%, which is reduced from the previous 30%. As such threshold aligns the allocation percentage under the first clawback trigger point of the revised mechanism A, which follows the approach under existing requirements. This will mean that the effective allocation cap under mechanism A and mechanism B would be 10% of the offer and 15% of the offer respectively. It will also mean that under mechanism B, there would be no reallocation or PO overallocation if the initial allocation to the public subscription tranche is 15% or more, as such initial allocation already meets the maximum possible allocation of 15% under the allocation cap. Under mechanism B, the allocation cap will continue to apply when IPO allocations under both the placing tranche and the public subscription tranche are fully subscribed or oversubscribed, regardless of the oversubscription multiple. This is because issuers adopting mechanism B already have the flexibility to decide on a higher allocation to the public subscription tranche at the initial stage. The exchange has not adopted the proposal to allow listing applicants to set the final IPO offer price 10% above the indicative offer price or the top of the offer price range after publishing the prospectus. The exchange has made consequential and housekeeping amendments to the placing guidelines in Appendix F1 to the Main Board rules. And the exchange has also made other consequential listing rule amendments. The initial public float requirement has been disapplied for bonus issues of a new class of securities involving equity warrants, if certain conditions are met. New provisions have been added to Appendices D1A and D1B to the Main Board listing rules, requiring listing documents to include a statement of the minimum prescribed percentage of public float. The initial free float requirement has been waived for overseas issuers seeking a secondary listing on the Hong Kong Exchange. GEM Listing Rule 1011A has been revised to require a minimum allocation of 5% of the offer shares to the subscription tranche, and Revised Practice Note 6 allows listing applicants to choose either mechanism A or mechanism B, as I mentioned earlier. The exchange has revised the listing rules so that for the purpose of calculating the expected market cap of new listing applicants that are H-share issuers or other issuers with other classes of shares other than the class being listed, The expected issue price of the shares to be listed will be used as the basis for determining the market value of unlisted shares. The exchange has also updated its guidance to clarify the basis for determining the market value of shares of an H-share issuer with other listed shares. The guidance is set out in the Guide for New Listing Applicants, Chapter 3.2 at footnote 2, and provides that for an H-share listing applicant that has other listed shares, the market value of its other listed shares, for example, A shares, is determined based on the average closing price of those shares for the 5 business days immediately preceding the date of listing on the Hong Kong Exchange, and the market value of the H shares being listed is the expected issue price. The exchange also revised Main Board Listing Rule 1202 and Gem Rule 1607 to require listing applicants to publish a formal notice on the date they issue a listing document for offers or placings where any amount placed is made available directly to the general public. Chapter 18B of the Main Board Rules has been amended so that the open market requirements do not apply to successor company warrants. An amendment has also been made so that the minimum market value requirement does not apply to SPAC and successor company warrants. So that brings me to the end of this presentation. Thank you again for joining me. I hope you enjoyed the webinar and see you again. Bye.